Kissel.
Thank you, Mr. Chair. To the proponent of the bill, through you, Mr. Chair, I've listened to you discuss the rights of free expression of a person's religion, and you seem to think of that as an absolute right. Is that correct?
Constitutionally, I believe that is an absolute right for our Constitution.
Do you believe that all of the rights extended under the Constitution are absolute? And I'll restrict that to the first 10 amendments to the Constitution.
I'm not a lawyer, so if I can understand where representative is trying to go with this, that may be helpful.
I'll ask a different question. How do you get to that right being absolute?
Being absolute, I don't know of any means where it would not be absolute. Possibly if the representative could give me an example of something where he believes it was not absolute, then I could give an opinion on that.
Through you, Mr. Chair, it's just my sense that we don't the rights extended to us under the Constitution are not necessarily absolute. For instance, the First Amendment, you don't have the right to say anything you want at any time. We've all heard the discussion about whether you can yell fire in the theater. There are regulations on the Second Amendment. There are regulations on the amendments which extend to us our rights that we call the Bill of Rights, the first 10 amendments. I'm just trying to figure out, through you, Mr. Chair, how Representative Morris, the proponent of the bill, gets to us having an absolute right here.
Through you, Mr. Chair, a good example is given, and I think others have talked about this earlier, is this is one of the rights that constitutionally the framers of the Constitution, the founders of this country, found to be one of the most important rights that we should have in this country. The right has been reinforced so much so that when we have a draft, we allow people not to serve in a war because they are conscientious objectors. There are numerous occasions in law where we have protected that right of individuals. That the government will not force upon anyone unduly something that would be an infringement upon their beliefs.
Actually, I believe that the U.S. Supreme Court, and this relates to what Senator Martin was talking about, has talked about what is a burden to people in their exercise of religion, their free exercise of their religion. And let me ask you this question so that I can understand what you're putting forward. In your Section 7 new language that you have here, you talk about religious tenets. Could you explain to me what religious tenets are, through you, Mr. Chair?
The tenets are they're basically the beliefs of any church, which normally, if you were to go to Catholic Church, they've got a litany of written writings and things that are their beliefs. I don't know the name of them. For most Catholic or Christian churches, you got the Apostles' Creed, but they may have certain deeply held and typically written beliefs that you'll find within their corporate bylaws or the articles of their faith. For more evangelicals, yes, it can be broad enough. Their belief may be that they believe everything from Genesis to Revelation. That could be the tenet of their faith.
So it could be something that is deeply held or something that is not deeply held, through you, Mr. Chair.
When we say deeply held, and this goes to the point that I think the other good representative from New Haven brought up, that certainly people within different faith organizations, each of the people there may not hold deeply to the tenets of the faith. However, the organization itself will have deeply held beliefs, which are the foundation of that organization. And those are the tenets which I'm proponing. I'm pushing forward here. This also goes to the issue again that Senator Hanley brought up. It is basically the organization. It isn't the lay members that determine, or a small subset of lay members that can really determine what the tenets of belief of that organization are. Every organization has some written tenets of their belief.
And that is understood. But as we look at creating the law, I think the intent of what we do is important. And quite frankly, not to be argumentative, but I am confused. On the one hand, you talked about, just before your last response, you talked about deeply held or things that aren't deeply held. And I understand the differences between religious organizations, but if you talk about things that are not deeply held, and then on the other hand, you talk about things that are deeply held, I don't know which of those matters to what's before me. So if you could clarify for me, are we talking about those things which are deeply held or those things which are not deeply held? Or are we just doing something broad stroke?
Thank you. Through you, Mr. Chairman, to the good representative from New Haven. Those tenets of faith, which I believe to be deeply held. When I say deeply held, that is certainly acknowledging that there are members of that faith that may not hold those, but the organization itself, because this bill, this amendment that I am pushing forward, that I have proposed, really talks about the organizations. It doesn't talk about individuals, if you know. It's the church or qualified church-controlled organization. It is a religiously affiliated organization. It is not the individuals. Because within any faith congregation, any faith institution, you'll have people of divergent opinions. But the deeply held, what I contend to be the deeply held tenets of that faith, are those which you will find in writing that have been codified by that organization, and they are the ones, to the good representative, through you, Mr. Chairman, that we as the state legislature must acknowledge whenever they are questioned. Those are those same deeply held beliefs that if a faith institution ever has to go to court to question or contend, it is those faith, it is those things that are written in law for them that I'm discussing here that they certainly could hold to as law.
And I appreciate that. I actually believe that if we're looking at the law of the land as put forth by the Supreme Court, that we're talking about, in terms of the burdens that were mentioned by Senator Meyer, but have been mentioned in other cases beyond this body, that we're talking about things that are central to the religion and also are deeply held. So I'm just trying to get a sense if that is the type of thing we're talking about here, or are we just talking about anything that has been written in, because I guess when we talk about the law of religion, I'm not sure what would be considered the law of the religion. So is it anything that would be written, for instance, in a Bible or in the Torah, or is it certain sections, or is it church documents? What are we talking about here?
Thank you. Through you, Mr. Chairman. I think the good representative has said the most important thing. He says, I'm not sure of anything that has to do with religion. And we as government, that isn't our role. That's why we stay out of it. That's why it's intended that we don't, because we cannot interpret for someone what their tenets of their faith are. The issue would be is if it's the good church of whoever came forward and said, here it is, this is what we believe, we then have the responsibility to honor and respect that, regardless of whether we believe it or not, regardless of whether we espouse it as our faith. Very often in this legislature, I have fought for the rights of religious denominations for things that I do not espouse. But I recognize that when we talk about balancing rights, it is important that we stand for what anyone's beliefs. So to the good representative, I'm not going to limit it to the Bible. I will not limit it to anything. It's whatever that organization, whenever they incorporate themselves, they're required by the state of Connecticut to provide their incorporation papers, their bylaws. There are articles that certainly would help anyone to understand what the tenets of their belief are, and certainly there are published documents that their hierarchy, because it is the hierarchy of that organization that would answer or to clarify for that specific faith, whether their compliance or whether they deemed that what we're asking them to do would be coercive or not. It wouldn't be we, the legislature. It would be a judge at that point in time based on whatever documents that organization could provide to show that this is their deeply held belief of their organization.